I'm going to step out of judge role and give you both some advice. The two of you are young, you are dysfunctional. If you want to have a life and a future, it's not together. You're toxic, all right? If he really did those things to you, then you have no business with him, period. And if you didn't, you have no business with somebody who would go to court and say that you punched her in the face if you didn't.
Yes, ma'am.
Thank you.
I think we all have a picture now of this entire situation. Would we all agree? So we're going to excuse you both while we deliberate in this matter.
This courtroom is now in recess.
They both better have a good counsel here, because I'm going to tell you the two of them should not be anywhere near one another. And the fact that a young woman at this age would even want to spend any time with someone who has physically assaulted her in any way, whether it's an intentional punch in the face or to pick her up, shake her, grab her, and toss her down, no matter what it is, I find just so troubling. And I stick to my original position, which is whether we find that he had these orders of protection or not in his favor, he owes her rent that he did not pay. To say otherwise would mean that any party with an order of protection who's ordered out for assaulting a spouse or a partner would then be absolved from paying rent. That just doesn't make any sense.
I do think that the obligation is to the landlord.
It is to the landlord. And with regard to the contention that she told him to stop paying rent, it came out through the testimony, at least it became clear through the testimony, that she was using from her savings to pay the rent. They, in fact, were in a position to apply and have it granted.
Okay, but what about this? She locked him out more than once after the TROs were denied and is still trying to hold him liable for rent.
But at that point, he still couldn't be in there because the court said
of protection.
Right.
So if he was improperly locked out, then he should be coming after her for constructive eviction. Otherwise, we have no alternative. I mean, as you said, it would make no sense.
There's there's obviously a hole in the law. There's it has to be
it doesn't make any
somehow
sense.
To address this issue. There may very well be. There is a law for the abused party in California who leaves a joint tenancy, for example,
is not responsible. Right, they're not responsible.
But if you're the abuser and you're kicked out, you're still on the hook.
Exactly. Otherwise, we'd be rewarding him for illegal behavior.
Just for my part, I'm comfortable deciding the case without passing on the veracity of any of these abuse allegations, because I don't think we have.
We don't have to.
As it stands, I think he's certainly liable.
I totally agree. So he owes her for those 3 months' rent.
Great.
Work for everybody?
I'm on
Good.
board.
Well, we've deliberated and we've put two things aside. One, we're not going to address on the validity of your COVID application because that's already been screened, and we're not going to relitigate your order of protection. Okay, so those two things we put aside. We were able to decide this case just based solely on the evidence that was presented here and the testimony. And what we have decided, sir, in the course of January, February, and March, you are responsible for your portion of the rent in January, which would be 1/2 of $1,725. Your portion of the rent in February, whether you were locked out or not, or by court order told to stay away, because that would otherwise reward illegal behavior if it were true. We're not saying it is, but we're saying that we have to look at this in a broad picture. So you would owe half of that. So that means for those 2 months, you would owe the plaintiff $1,725. As to March, once March 23rd came and he was permitted back in there, you would not be able to have locked him out. So we're only going to give you 3/4 of what his half of March rent would be, which would be $690. That brings you to a recovery of $2,415 that he would owe you for those 3 months' rent. However, you have to have more self-respect than to let somebody push you, punch you, verbally abuse you. Once you are hit, it escalates. If you're telling the truth about the altercation in any way, then this was not the first time, and you know it as well as I do. There's nothing for you to stay for, nothing. Now, that doesn't mean that you don't have a side to this. Because if what you're saying is true, if she frivolously goes down to a courthouse, makes you out to be some violent physical abuser, what the heck are you doing in it?
Right.
So no matter how we look at this, the only thing that's really, really clear besides our verdict is that there's no way the two of you can walk out of here friends and lovey-dovey and willing to work this out. There is no way that is going to happen. I don't know what else to say to either one of you. Judgment is in your favor. It's unanimous for the amount of $2,415. That's the verdict.